Want to see what made a judge so angry that they threatened to sanction that nameless person if they ended up wasting the court's time? Well, you're in luck, because it not only points out desperation, it not only works as a hilarious laugh track, but it shows exactly where that nameless person is right now. And I'll give you a hint. It's not a good place. It's not a good place at all. Fun times, huh? Fun times indeed. So hey there. Now, if you would, pause this video, share it far and wide. Every platform available. Make sure that information gets out. Leave a comment. Leave a like. That'll help this move too. Also, sub to the channel. Make sure you're still sub to the channel. And if you're not sub to the channel, well, check out that shiny button if you want to push it. Well, thanks. So the judge's reaction to this filing, it is beautiful. It tells you in no uncertain terms that the judge, they have moved past irritation. You could see irritation, too, in previous filings where they were saying turn over drafts, turn over emails. Well, now that judge, they've moved past that. They're moving into frustration. They're moving into anger. And they let it be known. See, this nameless person, they are trying to again get this case dismissed in Virginia. Third time that they're doing it. These attempts, they go back all the way to 2019, by the way. And the judge seems to pretty much be saying, yeah, that's been played out. By the way, why aren't you turning over everything that you're supposed to? See, the judge said, number one, you can present this argument. I will let you do it, but when you're presenting it, you pretty much have no chance of this happening. Number two, and more importantly, I think, when showing you the anger, they threaten sanctions if it's a waste of the court's time. And they're basically being told, you got away with it once, you got away with it twice, well, you know what, third time, that strike, you're going to be out. Now, the argument that they present, that's what we're going to be looking at here. We're not going to look at the whole 60 pages of it, but what they're saying is that we asked the court to apply the UK judgment and dismiss JD's complaint because the issue has already been fully and finally adjudicated by JD in another court of law. Essentially, it was decided in the UK, and that doesn't work out at all. So JD asserts that by applying his adverse UK judgment in this case would be futile, yet the law overwhelmingly supports and directs this legal application and dismissal. What they're trying to say is essentially it's been decided before, and that doesn't work at all. Why? Because if you look at who was involved there, it was JD versus NGN or News Group newspaper, The Sun, essentially, and Dan Wooten. The person we're talking about, that certain nameless person, they were just a witness in this. They couldn't be taken to task. The judge, they said that over and over again. And we have this little thing about new evidence as well. But they say, in July 2020, after full discovery, including use of all discovery taken in this case for 16 months, JD had his quote-unquote day in the court in UK, the libel capital of the world and plaintiff-friendly libel tourist destination where defendants have the burden of proving the truth of their statements. They really had to go out of their way that time, didn't they? So UK plaintiffs have a significant advantage in defamation cases, and despite this advantage, JD still lost. The UK court ruled against JD, finding that JD committed, we're going to say DV, against that nameless person at least 12 times, causing her to fear for her life. The UK High Court fully and fairly adjudicated that issue in the forum chosen by Mr. D, with a significantly lower burden of proof. Mr. JD burden in this case is to prove by clear and convincing evidence that he never committed DV against that nameless person. That person making that statement, by the way, was recording the entire time, didn't get any of this stuff on tape, but hey, it exists. Believe me, he needs to disprove that. Continuing. To permit JD a second chance to relitigate these adjudicated facts for the sole purpose of seeking a directly inconsistent judgment based on nothing more than the hopes of creating contradictory truths from the same witnesses and evidence only encourages duplicative and parallel litigation and predatory libel tourism. Further, it is contradictory to Virginia and U.S. law and a waste of valuable resources of this court and and the parties. Now, don't you find it telling, by the way, that the judge is saying, I'm going to sanction you if you end up wasting this court's time. Not only that, but you had in California, you had a discussion about charitable organizations. That judge said in no uncertain terms, you've wasted a lot of times. You've taken the hard route when you could have just turned this stuff over. Yeah, the irony in that. The irony indeed. Also, this idea of utilizing the same evidence. Listen to this here. JD has admitted that there was no witness he wanted to call, that he wasn't permitted to call in the UK proceedings, and has effectively admitted that there was no evidence he wanted to present that he was unable to present in the UK proceedings. I wonder. Charitable donations. Did he want to present that? Oh, yeah, he definitely wanted to present that. But hey, he doesn't want to do that. That's crazy to say. Not only that, you have body cam footage. You know that the guy is going to play that. But hey, what do I know there? You also have those letters, those pesky ones that just showed up. There are a lot of other things out there, too, that haven't reared their heads yet. Oh, man, good time. Now, skipping a few pages, we land here, and some of this is so irritating. So to reject the application of Virginia law these are the things they were making a case for, by the way, in this case, would be to effectively overrule and invalidate the UK judgment. In doing so, this court would be inviting, rather than ending, litigation by JD across the U.S. each time anyone, including the press, accuses JD of being a wife, and you know that other word rhymes with Walmart greeter, and committing DV against that nameless person, even though these statements are true as a matter of law. Now that irritates me quite a bit. Why? Because you actually had law enforcement officers involved in that case. Law enforcement officers said that they arrived there. They saw nothing that happened. There was no proof that any of it happened whatsoever. But hey, the judge that dismissed them, that makes this true. I mean, that is insane, isn't it? You don't have any charges. You have cops saying that didn't happen. But none of that matters anymore. That's the world that they're trying to make. This court's application of the UK judgment will remove these uncertainties and scenarios and comply with sound principles of Virginia and U.S. law. And then they basically tell you, the court, they should recognize the UK judgment and they should dismiss all of this outright. Now, JD's team, they ate that stuff up too. Different country, different laws, different parties. And that nameless person, they were only a witness. You can't take a witness to task like you can here, but in this, they'll be asked some difficult stuff, very difficult stuff, new evidence coming up too, and the judge, they seem to want this to happen. You let me know what you think about this though, and as always, appreciate the heck out of you. You make this stuff work. Thank you. Also, want to help out the channel? Links are in the description. PayPal, Patreon, membership, merchandise, but you being here, that matters, so thank you. Appreciate you. We will.